Good morning. Thank you very much for joining us today. I'm Sarah Guy. I am the Property Acquisition Officer from Planning and Growth Management, and I welcome you all today. Thank you very much for joining us. Thank you for coming at the little bit low notice. We only got this on the calendar about 2 to 3 weeks ago. So I appreciate you joining us today and learning with us what dedication and easement documents look like for the developer community as well as for the general public. I do ask that we please hold questions to the very end. I will be leaving plenty of time for question and answer at the end. You're also welcome online to type them into the chat, and we will cycle back to the questions that have not been answered through the course of the presentation at the very end. Otherwise, please do hold your questions, and I will leave plenty of time to get to them. One thing I want to start out with before we actually get into the presentation is a thank you to everybody who has given us patience and grace over the course of the past 6 months. Our entire right-of-way team, which is just the 4 of us here, have all been in our positions for 6 months or less. And during the course of everything that we have learned, it has been very much a dialogue with the developing community to understand what was done in the past for us to create the procedures and make sure that we're being consistent in the process.
I'm not getting any sound, so I'm just checking to see whether the meeting has started.
Checking to see if the mic is working now, please. Can somebody who just spoke up let us know if you can hear me now?
Rick, I can hear you.
Fantastic.
Just wanted to confirm, but they're still muted in the main room.
Great, thank you.
Thank you.
Mm-hmm.
Well, as I was saying, I appreciate the patience that you've given us and the grace that you've given us for those of you who have taken the time to call and let us know that you're experiencing some frustrations and working with us to collaboratively resolve those. What you see before you and what we're going to get into today is a result of what those collaborations have looked like and hearing the feedback from you guys so that we can solidify our processes. So I want to start by introducing myself. I am Sarah Guy. As I said, I'm the Property Acquisition Officer. I have about 25 years in the real estate community, both in the Southern Maryland region as well as in Fairfax County, working in land rights acquisition as well as general property acquisition. I'm going to ask my staff to introduce themselves to you as well.
My name is Victoria Rickett. I am the Assistant Property Acquisition Officer, and I have been in title, real estate, and lending for more years than I'm probably going to say out loud, but I am relatively new to the property acquisition part of real estate.
I'm Cindy Law. I have been with the county for about 6 months, but I worked at a title company for about 3 years prior to that, and previously a real estate company. So that's my experience.
Hello, I'm Bobby Baker. I'm a right-of-way technician. I was previously with the permits department, but I've been with right-of-way for less than 6 months, and prior to permits, I was actually in title work as well for about 4 years.
Good morning, everyone. My name is Cindy Jones. I am the Media and Communications Project Manager for the Department of Planning and Growth Management. I've been here for 6 months myself. Welcome.
Thank you. Next slide, please. I want to start with the basics of what a dedication is versus what an easement is and make sure that we're all using the same common language. So I want to reference what a dedication is, and we use kind of the dedication capital D versus dedication little d, and I want to differentiate what that means for us. A dedication is any conveyance of land, whether it's in fee simple or in an easement format for public use. That can be anything from a basic easement to an actual road dedication or something along those lines. When we say a dedication, meaning capital D, for our purposes, that is the actual fee simple transfer of land. An easement, for our purposes, is the legal right that gives a non-owner the ability to use a piece of property for a very specific purpose. And that can either be for public use or for private use or a combination thereof based on what's spelled out in the easement document. All dedication and easements run with the land. That means that at the end of somebody's ownership of a property, when it is being transferred to another party, That easement stays in place even though the owner is changing to a different person. Easements run with the land up until they are abandoned or up until the easement itself is dedicated in full in fee simple.
Excuse me, the folks that are online, none of us can hear you.
Sorry, just one second.
Yeah, we will try to work that out.
I think cable will work on getting access to those who can't hear online. Apologies if you're not able to hear. Cable should be working on getting that taken care of for you. Okay. Okay, and can you hear me now online, to the folks online?
Yes.
Yay! Fantastic. Thank
Thank you.
Thank you for the heads up that I was not broadcasting. I appreciate that very much. Okay, so we've hit a little bit on what dedication is, a little bit on what an easement is, the fact that everything runs with the land. Go ahead, Cindy, please, next slide. So the easements that we deal with as far as what you guys will see in the general practice is going to be either an off-site easement or an on-site easement. An on-site easement is whatever is impacting your subject property. So if your subject property needs to have stormwater, road dedication, wastewater, sewer, anything like that, that would be an on-site easement because it is on your affected property. If you are taking an easement from somebody else's adjacent property in order to accomplish the project that you are setting out to do, you are getting an off-site easement. For the purposes of what we are doing, we have limited use for off-site easements. It is usually just for critical infrastructure projects in order to be able to facilitate, and usually we see those as temporary construction easements, although there have been times when we've done permanent easements as well. Next slide, please. The beneficiaries of our easements are always going to be one of two different groups. We do label everything as either a public easement or a private easement. Public easement is almost always going to be for moving things from a public space across a private space. So for an example would be moving water from a public roadway across somebody's property to wherever it's being discharged. That would be a public easement. We're actually taking the public's whatever product they're generating and transporting it across a property. A private easement is moving something from a private property across somebody else's private property to wherever the outfall is going to be. So we use public and private easements when we are asking for those documents to be created for your projects. That is what we're looking at as original, where the need is being generated, where it's crossing, and where the end output is for that need for the easement. Currently, we have everything available for you online, and that is not going to change. However, what you see online will be changing soon. During the course of the past 4 months, as I've kind of had a chance to look at what the documents are that we've been using, I realized that we have been using a lot of the same templates for quite some time, and they need a little bit of refresh. They need a little love. We wanted to make sure that they are getting as consistent as possible for the way that we label parties to the agreements, so ownership and grantor-grantee, as well as some of the clauses that were not consistent from start to finish in all of the documents. We did not have consistent lien holder information in the documents. So we very much have cleaned them up. They will be available for public use starting in December. As soon as we get those documents updated, we'll send out a message and let everybody know exactly what's available. What you'll see is fewer stormwater easements for us to be using because we have a lot, and a lot of them are actually just very case specific, and we just don't need to use those because that case has now passed. We will also be adding in some documents that we are not currently providing because we are starting to see more of a need for those documents. So things along the lines of perhaps a sign easement or a retaining wall easement, which are happening more, I won't say they're not super regular, however, they're happening in more projects than we've had in the past, so we want to go ahead and offer that new template for you for your use. I will say that starting in December, you will see the exact same location for those documents. We will just request that you please use the documents that now have in the footer December 2024 revision date. All of our documents are always going to be located under the PGM website under dedication documents. We request that you only use what is the most up-to-date. So again, I will send out a notification to everybody once those templates are available, and we will request that anything that is submitted after that date uses the new templates. We're also trying to streamline some of the content of those documents so that you're not seeing multiple things to try to accomplish the same purpose. So we'll get into a little bit of some of those changes in just a minute. As I said, you'll have fewer documents for stormwater purposes and a wider variety of documents for non-typical easements that seem like they might start becoming more typical over the course of the next few years. So I want to get into a breakdown of the documents that we actually use, what their intent is, and when we would see them being used. Dedication documents, we only use 2 primary dedication documents for our development projects. We use a road deed or a road dedication, and we use a water and sewer dedication. Everything else, there would have to be a very specific need for us to have it dedicated, and it would be done through the county attorney's office based on what that specific need would be. These are our only 2 templated, fee simple dedications. We use a huge variety of easements, though. So I want to start with the most common ones, the very basic ones that you'll see, and then kind of progress through till we get to the most cumbersome of them. And I only say cumbersome because of the amount that we have of the forms. So we'll get into a lot of what the purpose of those is. The easements that we use, first of all, is water sewer easement, which allows for a water sewer infrastructure to be installed, however, does not turn over the complete ownership of that water and sewer facility to the county. It just allows for easement of or crossing over maintenance and construction of that facility within that easement. The forest conservation easement is going to be modified. It's going to have a little bit of language cleanup. However, the code provisions that it is referencing have not changed. So the content of the forest conservation is not going to change substantially because the code has not changed. We're looking to try to clean up documents to make them a little less legalese-y and a little bit more able for the average person to be able to understand what is being committed to that within that easement agreement. We are going to be refining our trail and travelway easement, mainly because kind of unclear when we use a trail, when we use a travelway, when we use a sidewalk. So we're in the process of refining what those definitions actually mean in our code and when it's applicable to use which type of easement for which type of purpose your project may need. So we will see some modifications to those, but again, the intent of those is to give permission for somebody to travel over a space of privately owned land to get from point A to point B. Site distance easement. For anybody who doesn't know, I have a favorite easement. I am a driver. I love a good site distance easement. They make me smile. The site distance easement restricts what can be planted in a site distance so that you can see safely to start pulling out into traffic. When you're at a stop sign, you're not basically being a dangerous driver to somebody else on the road. It does restrict everything between being planted between 18 inches and 96 inches. And there are some exceptions that the county will give to that site distance easement, but overall, that's the intent of the site distance easement. Make sure that we have safe ingress and egress to trafficways. Finally, as I said, the most cumbersome of the documents is the stormwater, and again, it's because of how many provisions are included within that one document. Within the stormwater easement, we have a public slope easement, we have a public drainage easement, we have a stormwater management easement, and we also have the agreement for inspection and maintenance. That's 4 major components that are happening in one document, and it's 4 very critical and interrelated components that have to be layered together in order to make a successful storm drainage easement. What that would look like for you guys is we're condensing everything down so that there's only going to be public storm drainage easement, private storm drainage easement. We're going to try to get everything all into one document. Your conditions,
Unknown
covenants,
participant is now joining.
your covenants and restrictions would still be in your covenants and restrictions separate from this document. Next slide, please. Thank you. Other documents that you're going to see or that we may request that you use that are not generally templated documents, but we have in our back pocket should you need them. Some of these will be made available on the public website, but we do have these available should they become required for your projects. First is an ingress-egress easement, almost always used for ingress and egress over like a private street, alleyways, things like that, to allow people to legally traffic over something that is privately owned. Sign easement, again, allowing for a sign to be installed and what the provisions for maintenance of that sign would look like. Maintenance of vegetation agreement is almost exclusively an agreement to cut grass in a median strip or some other public space, but it's usually agreement to cut grass. Quitclaim deed. We are in the process of actually merging our quitclaim deed provisions into the road dedication document. For our purposes, we only use a quitclaim deed for quitclaiming roads that are questionable whether or not we actually took ownership in the distant past. We feel like it's a better mix and a more streamlined process to have you have the road dedication mixed in with the language for the quitclaim, so that if that land has been encumbered but has not been transferred to us, it's all taken care of in one document. We don't need two separate documents anymore. We will be making available an abandonment of easement and cleaning the formatting of that one up. We are seeing more of a need for an abandonment of easement, especially when we're increasing capacities for instance, for drainage pipes or things along those lines, or we are relocating a location of a facility that we need to abandon where the previous location was. So we are making that available. And finally, we will be making available a temporary construction easement. We currently are not making that available to most developers, but how we are seeing the need for the off-site needs for you guys to be able to have a template. So we will be providing a temporary construction easement for the purpose of grantor and grantee not being the county. I want to talk a little bit about what is in the easement and what we are trying to make sure that we're making consistent throughout the language and all of the updates that we're doing to the templates. We want to make sure that we are consistently identifying the grantor and grantee and that we are labeling them as such, as opposed to covenantor and covenantee, or covenantor and grantee. We've had a lot of different verbiages used, so we're just trying to make it so it's consistent throughout our documents. We want to make sure that the property is always consistently identified. Plat book and page is excellent. However, meets and bounds description is far, far more beneficial for any sort of property identification. If you give us a meets and bounds, I will glow for the rest of the day. If you give me a plat, I will probably just mourn sadly. Covenants and agree statement will always be what is being offered on behalf of the grantor to the grantee, and that's what's saying, I'm agreeing to this. We use the phrase covenants and agrees, but that is basically the I promise statement. We use lien holder consents and partial releases. I want to talk, and I'll cycle back to this in just a minute, about lien holder consent. We have separated from all of our templates the lien holder consent clause. We are now not requiring that in the actual main body of the document. However, if there is a lien holder for any of the easements that are being obtained, it is the responsibility of the developer to obtain lien holder consent for any of the especially off-site easements that you are obtaining. That is not negotiable. That is a requirement by anybody who has taken out a lien, and if you're obtaining the temporary construction easement or any other type of off-site easement, you're responsible for obtaining the lien holder consent or partial release if that's required. Acceptance by the county is the final critical component of any easement document. It is all well and good to say that you want to give the county stuff, but if the county is not willing to accept it in the condition that it is in, then that granting did not happen. So the granting is only actually fully done once it is accepted by the county, and we say that we're willing to take on that responsibility for that, whether it's dedication or easement moving forward in the future. I'm going to talk about a few fun quirks of easements, and I do call them fun quirks. If you haven't figured out, I really like easements a lot, so I do think they're fun and quirky, and hopefully I will be able to share my love of them with you. The temporary construction's easements always expire at the time that project that is identified within the easement is completed. So a temporary construction easement for, let's just say, installing a stormwater facility can only be used for the time that that specified stormwater facility is being installed. That easement expires once that facility is installed and inspected and has passed. Easements are not transferable. They cannot be, you cannot assume that you can use the sewer easement to be able to put your storm drainage alignment over top the same. A sewer easement is not the same as a storm easement and vice versa. None of our easements are interchangeable. If you need a specific function to be accomplished by an easement, then your responsibility is to add a new easement in or verify that the easement that you are trying to work within already allows for the purpose of what you're trying to accomplish within that easement. All right, we've already talked a little bit about plats, but let me just reemphasize, plats are not easements. Plats are the location of where the easements are, but a plat does not convey the actual rights. And there is one example that the county makes an exception to this, and that is Old St. Charles. In Old St. Charles, there are some locations where we have, and through county attorney's office decision, have determined that a plat is an easement, is sufficient for an easement. Everywhere else, if you see a plat, unless we have the supplementing document that says what the easement language is and what the terms and conditions of that are, we assume that we probably do not have an easement in place. And we may request that even if it shows in a plat book, that you actually get the supporting document that outlines what that easement provision is in writing to support whatever's in the plat book. A couple fun, and again, I'm going to reference them as fun because easements are fun, a couple fun specific easement clauses. The stormwater easement says that the county has the right to inspect, provide reasonable notice, perform any construction that is necessary, and if the grantor is not willing to take care of any inspected and noted maintenance issues, that the county is willing to come in and do that, perform that maintenance. However, the private property owner would be assessed for the cost of that, and it would be wrapped up into your property taxes until that is paid off. That provision is nicely embedded into all of our stormwater easements so that we make sure that our stormwater facilities are constantly in operation and in good working condition. We also say in the stormwater easement that we have the right to access that easement from a public right-of-way or a public road. And the reason for this is there is a lot of stormwater easement that is located in the backs of people's houses. In order to be able to perform maintenance and inspection, we need to be able to get to that easement rather than creating an easement that goes across somebody's property just to get to that. The easement language within the document actually says that we have the right to access it from a public right-of-way or road. A travel and trailway says that at no time may the grantor charge for the use of accessing that easement. So for instance, if you have a private alley, nobody can say the admission fee to get onto this alley is $5. The admission fee to get out of this alley is $5. By creating that easement and allowing for pedestrian travel over it, there can be no charge for the use of the easement. And that's not just particular to trail and travelway, that's for all easements. But that one's particularly spelled out in that because we've heard problems in the past. Site distance easement, again, my baby, my favorite, prohibits any installation of any plants or objects between the elevation of 18 and 96 inches from the ground. This is a hopefully helpful workflow. I do have this in a bigger format to make it a little easier to see and to follow, but this is a little bit about the dedication document processing and bonding processing that happens within the county's workflow. So when a plan is submitted through EnerGov, through the CSS portal, it'll go through the necessary process for plan and plat review. On our side of things, I say our side of things being the right-of-way team, we will start collecting the executed documents. We do have to have the original executed documents in our hand. Once the fee is paid and we have everything that is part of that original document package, as well as the preliminary title report, we will assemble it and send it down to the county's attorney's office for review. We will not send it down for review until we have all of the documents that are required, because we need to correlate and make sure everything is taken care of and everything is showing the way we need it to. We also will not send it down without fees being paid or without a preliminary title report. We're going to get into, the team is going to get into in a little while why that title report is so incredibly important to us and what we're looking for when we're looking for that title report. After the county attorney's office has signed off on the documents, our permit, we will sign off to say that the permit is issued. And then the plat will go through the plat approval process, plat will get recorded. We will not record dedication documents until the plat is recorded. As soon as we record those dedication documents, we will notify you that we are ready for the final title report. One of the errors that you cannot see on this, but it is probably the most critical arrow for your guys' purpose, is the bond release arrow. Until you give us the final title report and we can verify that all of the easements that were obtained have been successfully recorded and now show as a part of the title history, we cannot authorize for bond release. Bond releases and the bond developer agreements, all of that is happening simultaneously but is not tied to the right-of-way work that we're doing. So that is handled by a different department, by PGM, but by a different person, different division. And bond issuing requirements are created at the time that we start with the plan and plat reviews. Before we actually have the permit be issued, you do have to have your development agreement in place as well as your bond in place. And then after your final inspection, when you're ready for the bond release, again, we can't release bond until final title report is done. So there's a lot of little tiny moving parts. We try to keep you in the loop as we go through. You may get messages from us saying we need this extra document, or this is not completed, or we can't submit until we have everything at one time. As soon as we have all of those documents in our hand with the original signatures, they go straight down to the attorney's office. We do allow them a good bit of time in order to be able to accomplish their reviews. They cannot turn everything around right away. So there is a few weeks that we allow for them to provide feedback and for us to do the follow-up to provide them additional information if that's necessary.
Okay, so to expand upon the flow chart that you just saw, I'm going to tell you a little bit about what the row team does. We call ourselves the row team. That's the right-of-way team. We start with the plan and plat and exhibit review. And when we do this, we'll have a full breakdown on the specifics of that, but we are looking at the plan and the plat and exhibit as a whole. As mentioned, part of our very important document package is the preliminary title report. This is an attorney's written review of the property's title. The PTR, as we call it, is required to verify ownership of the subject or site, to give the existing liens and easements and other encumbrances. It gives us tax information and verifies the legal description of the property. When we review this, we are reviewing it in its entirety. We compare the plat, plan, or exhibit to the PTR and make sure that all the information is matching. We may ask for clarifications about the different types of ownership, information that may go with that. So for example, if the property is owned by an LLC, we need to know that the person who is signing on the plat or the plans has the appropriate signatory authorizations. Same thing with trust and trustees. We want to make sure that we understand that the trustee that is signing on behalf of the trust is the appropriate person. This information is included in the preliminary title report. Sometimes we will ask for supplemental information to go with that. Sometimes we have to see a copy of the trust, things like that. What we are trying to do is to pre-review that for the county attorney's office. We want to make sure that if there's any typos, anything that's incorrect, any updates, all of that is put together correctly before it goes down for review. So once the documents have been received and we have reviewed them, we will review for things like typos, make sure the dates are filled out, the notaries are done, all of the stamps are legible, all that kind of good stuff. And then we will package those documents and send them down to the county attorney's office for review. When we send it, we want to make sure that we have a complete package. As Sarah mentioned, we do have to have the original executed documents by all parties, the review fee, and the preliminary title to go as a package to their office. So once that has been reviewed by the county attorney's office, they send everything back, it's signed, it's approved, it's good to go. But we hold them for recording until the plats are recorded. The only time that that may differ is if we have a plan that does not include a plat. and we're using exhibits as as part of our documentation as opposed to references to plats. So once those are sent down and prepared with the clerk's office, we will then again ask for that final title report. We'll send them the information and let them know that we have completed the recording of all the documents and that that final title report is to be submitted within 30 days. We work hard to make sure that is done because we do know that as things are coming about and you guys are finishing your constructions and everything, those inspections are coming. We want to make sure that we have everything in place so that everything can be completed as necessary. So I've told you a little about what we do. Here's what we don't do. We don't provide legal advice. We act as a liaison to the county attorney's office, but we are not attorneys. We don't play them on TV. We don't give out legal advice. But we will transfer your questions to the attorney's office if you need it. But basically, you should be relying on the attorney that you have engaged or your client has engaged to prepare the title work and other such documents. We don't determine what documents are required. That is done through the engineering contract review specialist. When you get your approval letters on your plans and plats, they let you know specifically what is needed based on your designs. We don't draft documents. If you need something special, you're certainly going to want to work with your attorney. As Sarah mentioned, we do sometimes have pocket documents that we can give as templates, but we don't do the drafting for you. That's for the attorney to handle for you. Also, as mentioned, we don't do bonding and development agreements on the row side of things. That is handled by a different person in the department, and she works with the county attorney's office to get those completed for you. Lastly, we don't enforce terms of easements. That's handled by the inspections department. We get them on record. We take care of the legal parts so that you guys can do what you do. So as mentioned, plan, plat, exhibit review. We do quite a bit of review on these documents, which might be a surprise to some folks, but we work really hard to make sure that we are catching all of the intricate details that need to be seen. So, for example, information on the subject property and adjacent properties. We verify ownership, library and folio of recorded deeds, tax parcel information, accuracy, spelling of names for roads, etc. We use the Public Records SDAT, this State Department of Assessments and Taxation's website, Maryland Land Rec, and our GIS maps to make sure that we are collecting all of the most recent information. We do look for the vicinity map to be showing on your plan, plat, or exhibit, and it needs to make sure that it shows your site in a legible format, big enough to see where it's at, but not so large that it takes up the entire piece of that county. We verify the general area, that it's accurate, and that everything is spelled correctly and shows appropriately. We do review the title block on your plan, plat, or exhibit to make sure that it has the right purpose. The page numbers are correct and in order. Sometimes it happens that they're not. So we review to make sure that the project purpose is there, the accuracy of the information. We do love to see the tax ID number of the property showing there, etc. We also check the owner's certification and signatory blocks. We do compare that to what is currently in the preliminary title report and what is showing on recorded deed. We need to make sure that all appropriate signers are represented. We also want to make sure that the legend that is used on the plan, plat, or exhibit is uniform and matches the referenced items in our documents and throughout the entire plat or plan. We need to make sure that the same hatching is used for each type of easement that is being included. We also check road names. We use the GIS map and cartograph to make sure that road names are showing the correct spellings, the correct classifications, that the library and folio, all of that information is included on each road that is shown. We also run into roads of use. I'm sure you're aware that there are roads of use in the county where the pavement is taken care of and maintained by the county, but we don't actually own the land under the pavement. This is a lot of the older roads in the county. If it is an older road of use, we will require road deed and quitclaim deed, which, as Sarah mentioned previously, will soon be one document, so it makes it a little bit easier. And again, hopefully that will happen in early December. We check the dedication area. If there's a dedication area along a roadway, we want to make sure that it's labeled with a purpose. If you are transferring and dedicating it to the county, it has to have a name so that we have something to transfer. Parcel A, parcel B, whatever you may have. We also make sure that the easements match the documents that we have. The easements have to be titled the same way they are going to be in your document so that everything is even and matches correctly. Again, we're going to be using those templates, and that should make things a little bit easier and more uniform as we go forward. Don't forget, when you send that document package, we do have to have the review fee. It has gone up a little bit this year, so it's going to be $165.90, and that can be paid with the time of the application with the package, or can be paid online via invoice. One of the things we do look at on the plans and plats is that the match lines all work together, that they're even and flow and go where they should be. And then the last two things that are really important to us, the square footage on an easement must show on the plat or the plan, and you want to make sure that that matches what is in your documents. And although I've saved it to last, I think it is really the most important thing. The plans and the plats must agree. The rule of thumb, if it's on the plat, it's got to be on the plan, and vice versa.
So I want to leave you with a couple final thoughts before we get to your questions. First, I want to share the fact that we are in the process of revising the PPP. So if you are not aware of that, hopefully those edits will be coming out in the very near future. I'm not sure exactly what the target deadline is, but the PPP is being updated. It will show all of the content that we just discussed today. So you will have, when you're doing your plan preparation package, full reviews, you will have everything that we just discussed in the PPP. Second, I want to bring to your attention the fact that the PPP is a guide. It is an outstanding guide that if you follow it from start to finish will result hopefully in only a couple review cycles and will get you a really high quality product. However, there are times that we cannot foresee what other types of reviews might be necessary based on very unique circumstances in your projects. I'm looking particularly at trust issues and legal issues that we have to resolve from the past to try to clear up maybe a concern about title or something like that. What we put in the PPP is really a guide to help you, but we may not be able to cover every eventuality, and that is where we will do additional requests for information. Also, due to the lifespan of projects, you may see requests for changes that weren't previously flagged in previous reviews, and that's as much as anything because we are coming up with a more consistent process that we are trying to stick to for every single review. And some of our projects I've noticed are we started them maybe back in 2018, 2019, 2020. There were some problems, things have been put on hold, and now we're reviewing them again, and we're seeing some stuff that we perhaps didn't catch in the past that we are asking to be addressed now that we've noticed that there might be a problem. Last thing I want to share is the fact that my goal is to work with you. This is a very collaborative process for developing the land in Charles County, and we cannot do this as a siloed group. We have to hear from you guys as to what you're experiencing in the course of actually being out and doing the land work, doing the site visits, talking to the people that you're working with. At the same time, we ask for some grace and patience when you're working with us because, again, none of us have been here more than 6 months in our roles. So a lot of times we're having to go and do research to find out what got us to this point. Why did we do what we did in the past? Is that the next best process to continue to use, or do we need to refine it because we didn't address this eventuality? So I ask that you please give us some patience, but also please give us a call. I am very much a fan of email because I can always respond when I'm in another meeting, but I feel like the best way for us to communicate is for you to pick up the phone or come and see me or one of our team members in the office so that we can discuss your problem if you actually have something we can't work out by email. This is, as I keep saying and want to reemphasize over and over, this is a collaboration. And we are here to help support you, but we also do need to make sure that we're taking care of the residents of the county as we're doing that. With that, I will open it up for questions. What do you have for us? Oh my goodness, is this the first time in the history of development that nobody has questions? That can't be.
This is Rick Barnes. I've got a question if no one else does.
Go for it,
Can you
Rick.
hear me?
Yep, go for it.
Okay, great. Well, first of all, this is really well done. I appreciate the time and effort you put into this. This is a great summary. The question I have is on a project where you're phasing the infrastructure and from section to section, if you record a public easement that's outside of a road right of way because it's in a future road right of way, so if you let's say it's a public water line that's being extended outside of your right of way, if you're then on the next section recording a public road over that same easement, you have to abandon that easement since it was already conveyed to the commissioners, or just get absorbed in the road right of way?
No, it would be absorbed. Actually, we would ask for a dedication for the water and sewer component, and it would be part of at the time that you dedicate the road, you would dedicate the water and sewer. It would not be abandoned. An abandonment is for when that line or facility is not being used ever again. And we do not want to do an abandonment if there is something that is going to continue to be used for it. So we would just ask for a dedication and for it to show on the plans and plats as a dedication instead of an abandonment. Thank you for that question.
Perfect. That was my understanding as well. Thank you. Appreciate it.
Yep, absolutely. Anything else? Cindy, do we have any questions in chat? Oh, Doug.
Could you give us an expected timeline for the review and approval of the documents when they're initially submitted? And I understand that you can't be exact, but
Sure.
let's just say
Sure.
we submitted perfect documents, everything was there that you needed. How long would that review process take?
So thank you very much for the question. Doug's question for anybody online who did not hear that was, what is the turnaround time if you were to submit a perfect package to us with all of your dedication documents, everything's original and executed and in perfect condition, how long does it take to get that through the process? I would say generally 2 to 3 weeks is a normal turnaround time. Again, recognizing the fact that we have other people whose timeframes we have to look at. So that is both paralegal and county attorney have to have a look at it. So I think that's a reasonable turnaround time. We are trying really hard to not go that far and to have it done much faster. But I will say that the team, we set reminders for ourselves for follow-up. So if we're not getting action right away, then we will do a gentle reminder. But I don't think that in the 4 months that I've been here that we would need to do have needed to do a gentle reminder. It's usually within that time frame.
Would you mind using the mic, please? Our persons online are saying that they can't hear our in-person participants.
Yeah, Tim, if you don't mind coming up and...
Thank you so much.
Tim Lessner with Lorenzi Dodds and Ganell. A couple questions. One, you mentioned like sign easements and retaining wall easements. Are those, if we show those on plats and on the engineering plans, which they're usually private, are they now part of the package that we have to provide? And would you record those?
So it really depends on how that is put on your plan or plat. If it's put up as a private retaining wall easement, we do have documents that come to us. We'll get them reviewed to make sure that they include the correct verbiage. Generally, we will ask to allow us to record it along with the rest of the package. It's not required per se, as long as we get a copy of it that's been recorded. But the idea is to keep everything linear and make sure that things are going together. So if we're able to obtain that from your attorney who's preparing it, we'd like to get the original as part of the package for recordation.
Okay. So if you record it, is there a separate fee for that?
So it depends on how it's written. If the county is giving acceptance, there may not be a separate fee. But if it is private between private parties, then there generally is a fee for that with recording. So you would just submit the fee along with the package.
Okay. So when we, most set of engineering drawings have a easement composite plan. Is your staff now going to be part of the initial review of engineering of like a step 3?
If it goes through Intergov, our team is looking at it.
Okay.
Yes.
Okay. So each submission, if there's a second and third and fourth submission, you will.
If we have marked it as approved for right-of-way, it will not come back to us. However, if we've marked it as requires resubmit, then it will come back to us until that condition or provision has been corrected.
Okay. And just if there's a odd easement, like we've had like sidewalk easements, they're now going to be part of what you're calling like a trail or a travel easement?
Yeah, we're working with county attorney's office to figure out exactly what language that we're going to use because of the fact that the code actually defines sidewalk and defines trail and defines travel way. Each thing is separate, so we're working on trying to figure out what we're going to be using. Short answer is yes, we're going to get that refined.
And all these new documents are all coming out in December, is that
Yes,
what you said?
that is our goal.
Okay.
Yep.
Are you also reviewing forest conservation easement documents too?
We have started that process with the Forest Conservation Team, yes.
Okay, so normally those documents just go to Kyle or
Yes.
somebody in the planning office. He's now going to ship those over to you?
Oh, no. Kyle will still be handling it. We're just doing the revisions of the content within that document to make sure that it's, like I said, meeting the same standards as the rest of the easement documents that we use, but Kyle is still the point person for that.
Okay, so once you come up with the new document, you're done with it?
Yes,
then?
so
Exactly, yes.
we are assisting with the template, and then once that has been approved, then it will be used just like you normally do.
Okay, so it goes to planning office, they'll check it, and then it will go right to the county attorney's office?
Exactly,
You won't
yes,
see it? Okay.
exactly. Yep. Thank you.
And thank you, this has been great.
Absolutely, thank you. Mary, come on down.
I haven't been involved with the development process in a long time. My question actually refers to or references a repair that might require easements across private property. Is that something that your department is going to handle?
Potentially. I do see that we also have some folks on here who are from Public Works, so if you want to go ahead and throw the question out, I'll tell you whether or not that's something I can answer. If not, then we do have people from Public Works who can follow up with you directly afterwards. Because I'm only going to speak to what I am comfortable in answering the question, so go for it. Let's hear it.
Sure. Well, I guess the question is if there is a property that has a failed stormwater part of the system that originates off the property, are easement documents required to get to if the repair needs to start up here, but the damage is caused here, what is the process for getting to that and making that repair possible?
So short answer, and I'm going to give you a very short answer because this is a very lengthy question.
Okay.
So short answer is first thing that we need to do is look at a title and find out what easements are actually recorded and find out what permissions are actually on the books right now. And then do some background work to find out what that would allow us to do, what that would not allow us to do, and if we need new easements put into place, what that would look like. What I would like to do is follow up with you after this. The person who you want to talk to is actually not Public Works. It's probably actually going to be in PGM, and we are working on very similar projects along this line, so I'll put this in his ear and ask him to follow up with you directly, if that's all right.
Okay, and a quick follow-up to that particular question. Do you have a general idea of how far back these less than regulated development plans and easement plans, when did the county when did we recognize that it was important to pay more attention to how things were developed and that they were recorded? I had a couple questions about easement docs, especially if they were in connection with liens. Who's responsible for having this releases prepared and then recorded?
There is not a single easy answer to that because technically speaking, it's on the lien holder as much as it is on the person who is working to get that lien, or excuse me, to get that easement in place. So that is more of a legal type question as far as exactly whose responsibility it is. For when we are using requiring off-site easements as part of a development process, then it is on the developer to do that lien holder release obtaining, because it is a provision of the development process.
Right.
But that is the only one that I'm comfortable in saying that's whose responsibility it is just for the developers.
Okay, and then from a real estate standpoint, you mentioned that there were easements in Carrington that are either not recorded. Explain that again,
It's
please.
the paperwork that it actually says, whereas this provision, we are now taking this and the terms and conditions look like this. We don't have that supporting document. That was never recorded by the original St. Charles Development Company. And so what we have used, because the intent was there at the time that they created the conditions, covenants, and restrictions for that neighborhood, it was put in that the purpose of the recorded plat book was to show the easements. For that community, we're assuming that plats are easements. Again, there's a lot more.
Way over my head. I just call you if we get a listing in Carrington.
That sounds perfect. Thank you. Any other questions? Anybody online? I see we have somebody online who may have a question. Cindy, is there a question in the chat that we need to worry about?
There currently isn't.
Okay, thank you. Any last thoughts or questions? Yes. Sure, please do. Exactly. That's why we're here, is to give you the opportunity to do so.
So my question is, do all dedication documents need to go to the county attorney's office for review?
Yes.
Even though they are all specific templates that
Yes.
we all have to use? I mean, I don't understand why that's necessary. I can understand if there's, something out of the ordinary, but it just seems that.
Because we have a couple very creative folks who like to modify.
But you all can look and see if the language matches.
Yes, we
right?
do that through county attorney's office.
So you don't want to do that. That's it.
That's not a matter of wanting to do. It means I'm not qualified to do that at that same level that the paralegals and attorneys are qualified to do that.
If I may add to that answer, keep in mind that part of the review process that we're discussing is also the signatory process. It all happens together. So not only is the county attorney's office reviewing the documents to make sure they're what they need to be, they're also working them through the signature system. So that's a seamless process that happens all together.
And I'm not trying to be dismissive of what you're saying. What I'm saying is the reason, anytime we put something into place, the reason is almost always because something triggered a need for us to put additional attention to detail or additional eyes on something. And what we found is that there was some manipulation of the documents that we accepted perhaps a little too in good faith, and found that it was not what we needed to see happen. And so now, to ensure that everything is consistent, we just send everything for review and then signature all at one time.
So back to your statement, Vicki, that process of going to the county attorney's office also includes getting whatever county signatures are required on these documents, and then the executed documents come back to you all. You hold them until the plats are recorded, then that's the trigger to record the documents.
Yep, that's correct.
Yes. Yep. And that's all within that 2 to 3 week window of time that happens. So that is the communication of, we need this change, can you please get this change to us, as well as the actual signing off on anything that's provided.
Okay, thanks.
Absolutely.
Really appreciate this. It's been very helpful.
Good, thank you. Thank you. All right, I'm going to open myself to a world of hurt, potentially. What other classes do you want, or training or information can I provide for you? My goal is to make sure that I am being as open as it's possible for me to be in the decisions that our team uses and the processes that we use. So if there is something that you would like to hear us do, including the people online, if there is a right-of-way or property acquisition type class that you would like to see us provide, I would love to hear that. And Sue, I see you have a question.
I do, and it's actually more geared toward, I think, and this may have already been resolved, and if it is, say, Sue, stop talking. But I know there was a question when you have overlapping easements. So you've got the water, the sewer, maybe some other easement, stormwater, whatever it is, road. I know there were some concerns with how to depict those on the plans and within the documents, how to label them. And so was that resolved, or is there any insight or direction that you could give on that? And if you want to hit me up later, that's fine too. But I just know that I've seen that, and I'm sure you've seen it as well.
I actually think that's a very good question, and I would like to answer it in this format rather than following up online, because I think that's probably applicable to everybody. That the question is whether or not, make sure I'm understanding Sue's question, whether or not we're asking to break out easements that overlap. So for instance, you have a private access easement as well as a water sewer
Correct.
easement. That's absolutely fine to have them overlap in the plan and project. However, what we need to see in the actual easement is an indication of where the two are, so we can separate them and understand if they overlap 100%, then the legend can show it's private access, public water, public sewer, whatever the thing is, as long as they overlap 100% and there is no give at all. If there is even the slightest deviation of overlap, then we have to see them called out separately in the legend and hatching. Hopefully that answered your question, Sue. If it didn't, please let me know.
Nope, it did. That was exactly what the question I had. So I appreciate that, because I think that helps me, and I think hopefully it helps everybody else.
Excellent, thank you. Any additional questions? Go for it, Tim.
Into the weeds here.
Okay.
So you also somebody mentioned that you want square footages on all these easements. We've never done that. We do it for certain types of easements, forest conservation easements and whatnot, but like a drainage easement that's clearly 20 feet wide, 50 feet long in its dimension, but we've never put square footages
Are
on.
you giving us a meets and bounds or some other description that we can identify if we were to send a surveyor out to
Yes.
find that, you're giving that to us? That's fine. That's fine.
Okay.
We're not going to sweat over
No,
that.
we put bearings and distances on it,
And-
so
and
they're
that's-
all tied down.
And that's what I'm concerned about, is being able to see that I can calculate the exact square footage. And
You
if I
could.
send a surveyor out there, that they can find that exact location of that easement. What we generally find is that many of our service providers like to use square footage. That's fine.
Okay.
They like to do acreage. That's fine too. But we need to know exactly where it is so that the average person can go out and locate it.
Right. And then as far as templates, are you going to come up with a common use access easement too? Like for private roads for 3 or 4 or 5 lots?
Highly unlikely, but let me actually table that and get back to it. Let me talk with the county attorney's office.
Yeah. I mean, I really don't care. Most of the attorneys probably do because they all use a little different languages here and there, but
Are you thinking ingress, egress, or are you thinking road maintenance?
both.
Okay,
But for private roads.
right.
And just in the last, I'll say, year or two, your office is required to see those, and then we give you a fee, and then you take it over and record it yourself. I guess we're going to continue to do that also.
Yes, yeah.
Okay.
That is our process of verifying that it's actually being taken care of. And it's an effort to try to facilitate things and make things a little bit easier for the entire process, because we almost always get those documents at the same time we get the other documents that we're recording. So it just makes it seamless for us to check that off. It has been done. It's been done right. Then we can take it and record all the rest of the docs.
Right. I mean, that's not a document, I don't think, anyway, that we would normally do a title report for.
No, not generally.
Yeah. Okay.
Thank you.
All right.
Any more in the weeds questions? We're here to be in the weeds. That's the point. No. All right. Well, I thank you all so very much. Hearing your questions gives me some food for thought, and obviously some questions that I want to go back and follow up with various people that I work with to get some clarity, to perhaps forward some people to be in touch with you, Mary, about your question, and just to look at generally at our processes and what we can do to help support you guys even further. Again, I want to reemphasize the importance of please being in communication with us. If you are frustrated, chances are we are too. Let's be unfrustrated together by working out what that solution is. I will leave it at that, and thank you again for joining us today. And thank you for recording, Cable. We are done for the day.